Honorable Vice Chancellor, sir, dignitaries, the resource persons from both within India as well as from abroad, participants, ladies and gentlemen. A very good morning to all of you. And maybe I should also say good afternoon and good evening, depending on from wherever you are watching this event. Let me first thank our Honorable Vice Chancellor, as well as all the other dignitaries, my friends and colleagues who have actually accepted to be part of this particular one-day discourse on the impact of COVID-19 on the aviation law. I can see many of my abroad colleagues being readily available for the inaugural itself. I can see Professor Anis, Professor Attila, Professor Jessica, and even Professor Divya Tyagi from GNLU. Many of my other colleagues and friends, all of them I can see here. Let me first actually thank all of you for accepting the invitation and being part of this particular endeavor. In my opening remark, here I would just like to highlight certain major uncertainties, that too from the legal point of view, because actually most of you should be already aware of what kind of practical problems the aviation industry is facing, or it was facing even before the pandemic. Now, my focus is only in terms of outlining certain legal uncertainties which have actually affected the aviation industry much more during this pandemic. I think most of them will be carried forward in the subsequent presentations, and the resource persons as well as the paper presenters would be discussing in detail about each one of them. We are under the devastating pandemic. There is no doubt in terms of that. Two waves have already hit. We can't say that it has stopped, it's also continuing. The third wave is expected very soon. Already more than 21 crore people have been identified to be infected. Don't know how many more were infected but not actually tested. Right? So more than 21 crores has been identified as the COVID-19 infected people. And almost 43 lakh people have died across the globe, which clearly indicate that we are evidencing something which is catastrophic in the history of the human beings itself. A lot of measures were taken for the purpose of protection of public health across the globe. And it has been spread over different sectors. The aviation sector has also been part of that, starting with the North Korean restrictions in February 2020. North Korea became the first country to impose COVID-19 restrictions, closing their airspace with respect to the other countries' aircraft in February 2020. And this pursuit has been followed by almost all other countries, especially for the purpose of protection of public health. Effect is something, again, devastating on the aviation sector. There has been a decline of the air traffic at least by 60% in the last 1.5 years. And a loss to the aviation industry, as of now, is estimated to be more than $500 billion, which has been the ICAO estimate itself, more than 500 billion. Out of that, 370 billion by the airlines themselves, and airports under 15 billion, and air navigation service providers have also added upon another $13 billion losses. So an estimate of over $500 billion is the total loss which has been suffered by different the players in the aviation sector. Most of the airlines, they are having the threat of bankruptcy. As our Honorable Vice Chancellor mentioned in his welcome speech, insolvency proceedings are becoming more common. I should say that aviation industry, even before the pandemic, has been fragile, and especially in the countries like India or other developing countries, there has been a lot of problem with the airlines. Maybe due to supply being more than the demand, maybe due to the stiff competition to remain afloat in the market. For different reasons, most of the airlines were bleeding even before the pandemic hit them. And I should say that this pandemic is in a way fast-tracking the bankruptcy of most of the airlines across the globe. There is an estimated job loss of 3 million It's a staggering figure. Yes, 3 million people in the last 1.5 years, almost a job loss to the extent of 3 million happened in aviation and related sectors. Right? So I'm not saying hardcore aviation sector itself, even those industries which are related to the aviation supplies and all, taken together, job loss estimate shows it to be around 3 million. ICAO estimate once again says that there is a threat to the economic activity to the extent of $1.8 trillion. $1.8 trillion, a staggering figure, maybe much more than the economy of many of the developing countries. So that's the amount of the loss which has been estimated in the economic activities across the globe, especially due to the stoppage of the air traffic. Right? So therefore, there has been a huge effect of the pandemic and the measures taken in connection with the pandemic on the aviation industry. Now, the first legal question with respect to this is whether the international aviation law permits such kind of a closure. From the legal point of view, if I have to explain, I have to start with, is this permissible? Right? So there's a complete closure in many of the cases or partial closures, etc. Is this permissible? I need to look from the point of view of the Chicago Convention and its related instruments. As many of you must be aware of, the principle which is applicable to the airspace has been the principle of sovereignty. State has got exclusive sovereignty, right, complete and exclusive sovereignty over the airspace above its territory. However, this complete and exclusive sovereignty is subject to the right of innocent passage of other countries. It's not an absolute sovereignty without any restriction. Other countries do have certain freedoms or they have got certain rights with respect to the use of the airspace. And this freedom or maybe this right of other countries to use the airspace are adequately reflected in the International Air Services Transit Agreement and International Air Transport Agreement, the two agreements which are entered along with the Chicago Convention. There are totally 5 freedoms which are available under the agreements: the right of overflight, right to halt for the non-traffic purposes, right to carry the traffic from the state of registration to a foreign state, then right to carry the traffic or maybe the passengers and cargo from a foreign state to the state of registration, and finally, right to carry the traffic from one foreign state to another foreign state outside the state of registration. So these are the 5 different freedoms which we can find in the transit and more importantly in transport agreement, because the transit agreement contains only the first 2 freedoms, transport agreement contains the all 5. Even though air transport agreement has not been ratified by many countries across the globe, several of the freedoms enshrined under the air transport agreement have been granted under the bilateral and plurilateral agreements. States have entered into the bilateral and plurilateral agreements for the purpose of granting the different the freedoms available to the other countries. And restrictions on these freedoms of other countries can be imposed under certain circumstances enshrined under the Chicago Convention itself. There are some provisions mentioned therein wherein the states can take away the rights of other countries with respect to the use of their airspace. The key provisions which I would like to point out here, first of all, is Article 9B of the Chicago Convention. In connection with the COVID-19 restrictions, these are the relevant provisions. Article 9B of the Chicago Convention, which reads as what is mentioned in the slide. Each contracting state reserves also the right in exceptional circumstances or during the period of emergency or in the interest of the public safety and with immediate effect temporarily to restrict or prohibit flying over whole or any part of its territory on condition that such restriction or prohibition shall be applicable without a distinction of nationality to aircraft of all other states. That's what it says. Of course, we can easily understand that the current restrictions may fall within the ambit of the emergency, right? So, a response to the emergency or maybe the public safety. Yes, of course, we can accept that. But there are 2 qualifications under Article 9B which I have highlighted in the slide. Number 1, it speaks about temporarily to restrict or prohibit. So that should be temporary restriction, not a perpetual. And how long could constitute as temporary is a debatable issue. That's one of the debatable issues. Can we actually close our airspace for years together? Is it a temporary restriction or prohibition? That's really debated. Then, second significant thing is towards the end of this provision, which speaks about without the distinction of nationality of the aircraft of all other states. That means that should be following up the most favored nation treatment, MFN treatment, right? So there should not be any kind of a discrimination between the aircraft of different countries with respect to the entry or exercise of the rights. And there may be some, say, country neutral restrictions imposed by certain countries, but there are also restrictions imposed by the states which are country specific. If you look globally, the COVID-19 restrictions, whatever have come up in the aviation sector, some of them are not uniform. They are not applicable across the globe for all the countries. They are selective for certain countries. So they qualifying the test of Article 9B is really debatable. So those kind of restrictions, I don't find that they would be justifiable under Article 9B of the Chicago Convention. Next, one of the most significant provisions with respect to the current circumstance, and which remained as a kind of a dead letter law over the period of time, has been Article 14 of the Chicago Convention. Article 14 of the Chicago Convention, which speaks about prevention of the spread of disease. Prevention of spread of disease. Again, it reads as mentioned in the slide. Each contracting state agreed to take effective measures to prevent the spread by means of air navigation of cholera, typhus, smallpox, yellow fever, plague, and such other communicable diseases as the contracting states shall from time to time decide to designate, and to that end, contracting states will keep in close consultation with the agencies concerned with the international regulations relating to sanitary measures applicable to aircraft. So it has got different parts. Of course, the major focus is the prevention of spread of disease. It enlists a certain kind of communicable diseases. You can find cholera, typhus, smallpox, yellow fever, and plague being explicitly mentioned therein. And then it leaves the discretions to the state, the contracting parties, to declare or designate some other communicable diseases within the ambit of Article 14 for imposing restrictions. Right? So it basically allows the states to designate certain other communicable diseases within the ambit of Article 14. And the last part says that for designation of those communicable diseases, the states or state parties can consult with the international agencies which are concerned with the sanitary measures applicable to the aircraft. As of now, ICAO has explicitly recognized the WHO, right, the World Health Organization, with respect to such kind of a consultation for taking action under Article 14. And if you look into WHO has got international health regulations, IHR. Article 28 of the IHR clearly says that with respect to the aircraft's entry or exit, no restriction can be imposed unless and until it is justifiable under Article 43. State need to justify it under Article 43. And if you go through Article 43, amongst many other requirements, there are two things which are very, very predominant under Article 43. Before taking any kind of a restriction or prohibition with respect to the flight, two things need to be complied with. One, that there should be sufficient scientific evidence. There should be sufficient scientific evidence to the effect that the closure of the airspace or maybe restrictions regarding flying has to be imposed. That's number one. Number two, any measure taken by the state for the purpose of protection of the public health should be the less restrictive alternative. It should not be more restrictive than what is necessary in a given set of circumstances. So these are the two crucial elements to be proved before taking a measure or a restriction as per Article 43 of the IHR. And whether the COVID-19 restrictions do comply with these two elements is again a debatable issue. That's again a debatable issue. And you have to test each of the measures independently under these twin requirements and find out whether they qualify the requirements of Article 43. Added to that, despite actually declarations by many states about the restrictions or prohibition on flying, none of them interestingly invoked Article 14 of the Chicago Convention. You can go to the ICAO website where the declarations are available. They haven't specifically mentioned that we are designating COVID-19 as a communicable disease under Article 14. These restrictions are imposed under Article 14 of the Chicago Convention. I couldn't find any such kind of a declaration by any of the states. So Article 14 application is also in a way debatable, even though there is a high possibility of invoking Article 14. Then there are some other scholars who are trying to argue on the basis of Article 89 of the Chicago Convention. I find that it is not relevant at all. Article 89 is more in terms of war or other national emergency. And the other national emergency under Article 89 is more related to the armed conflict, or maybe more related to actually some kind of the conflict, not related to the public health measures. So that is why even Article 89, I'm not very sure of that. So legal basis of the closure or restrictions imposed by different countries itself has got certain kind of actually limitations if we look from the perspective of the Chicago Convention and the other international related instruments. Now, let me just take another 5 minutes to tell you what are the other legal concerns which the airline industry is going to have once these restrictions are eased out. Once these restrictions are eased out and once they are planning to come back to the business, what are the other concerns? First of all, they have already actually left many of their employees, or even actually they are on half pay or maybe very less amount of the pay. Most of them have taken alternative employments. And the airlines, if they want to come back to the business and start their activities, they need all their experienced staff to come back to the business. How can they do that? Retaining or maybe getting them back to the work is almost an impossible task, because most of them, number one, had got the bitter experience in the aviation sector, being thrown out without any livelihood. Number two, they've already taken an alternative employment. So why should they think in terms of coming back to the aviation industry? So that's one of the major problems which they are going to face. Also, a lot of issues with respect to the employment laws, right? So maybe litigations already are pending with respect to the pending wages, or maybe with respect to the, say, throwing out from the employment. There are a lot of litigations which are being faced by the aviation industry. Next, another very, very key problem which the airlines might face would be in terms of the liability towards the passengers, consignors, and the consignees. Because if you look into the Montreal Convention 1999, which basically speaks about the carrier's liability with respect to any kind of injury caused to the passenger or damage caused to the baggage or cargo in the course of the transportation. The Montreal Convention brings in a norm of strict liability. It brings in a norm of strict liability on many aspects. One such aspect can be found under Article 17 of the Montreal Convention, which speaks about the injury to the passengers. Injury to the passengers. And it says, to the extent of 100,000 special drawing rights, the carrier is strictly liable to pay compensation to the passenger for any injury which he or she suffers out of accident which happened on board the aircraft or during the course of embarkation or disembarkation. So if in the course of transportation, if any injury happens to the passenger, carrier is strictly liable to the extent of 100,000 special drawing rights. And the possibility of a passenger getting infected with COVID-19 during the course of the transportation is very much possible. It's very much possible. Going by Article 17, right? So if the plaintiff can prove, please keep in mind that there is a requirement of a proof on behalf of the plaintiff that the COVID-19 infection has happened in the course of transportation, especially either on board the aircraft or in the course of embarkation or disembarkation, which is difficult, that is true. But we have a lot of lawyers who are capable of arguing that and trying to establish it actually. right? So therefore, there is a possibility of claiming against the carrier huge amount of compensation on the ground that passengers are infected with the COVID-19 in the course of transportation, despite the fact that the carrier has taken all precautions. Because that all precaution by the carrier, that defense is no more available under the Montreal Convention. It's a strict liability to the extent of 100,000 special drawing rights. So that's why there is a possibility of passengers claiming compensation. Again, there might also be a possibility of damage caused to the cargo or maybe baggage due to the delay. Due to the delay in the transportation, the thorough checking or safety measures might result in the delay, and damage might be caused out of that. So precisely because of that reason, carriers might be liable to pay huge compensation. Next, they have the problems with respect to the certificate of airworthiness. Another legal issue, because the aircraft can't fly without the issuance of certificate of airworthiness by the state of registration. We know most of these aircrafts are grounded for almost 1.5 years now. How can they get a certificate of airworthiness? So I'll just take 2 minutes to wind it up. Okay, right. Yeah. So, certificate of airworthiness, how can they get, especially for these which have not been functional over a long period of the time? And would there be a requirement of overhauling the engines? So if that is the case, how much of the cost may be incurred by the airline industry? That's again a problem. Then, catering to the interest of financiers, because the financiers are more concerned about getting back their investment. They're not concerned about what kind of sufferings the aviation industry is undergoing. They want their investment back with the interest. Already, a lot of litigations have been filed by the financiers against the owners of the aircraft. And in catering the interests of the financiers, these owners of the aircraft or the carriers who are not making any business at present are going to have huge problem. Finally, we are also going to have updated safety norms. In the wake of COVID-19, definitely more and more safety norms are going to come, and that is also going to be different in different parts of the world. There will not be uniformity. A lot of complaints costs will be there. The airlines need more staff. They need well-trained staff. So ultimately, what might happen is that they have to spend more with respect to training of this staff, and they have to incur additional expenses. And all these additional expenses, they would not be able to transfer it on the fare, because increase in the fare means there will be reduction of the consumers, especially in the developing country like India. We can't expect that with the increase in the fare, more and more people can dream of flying. Right? So precisely because of that reason, increase in the fare to meet all these costs, increase the cost of the aviation sector might not be an option. That's definitely creating a lot of problem to the carriers. Added to that, there might also be a problem in terms of actually the nationalization. Some of the debates about the nationalization of the aircrafts are also being going on. So it might also create problems to the carriers as well as the consumers. That's all from my end. It is just an opening remark, and I'm sure that actually the subsequent presentations will carry forward from all these things which I have basically highlighted. And I hope that all of you will enjoy this one-day discourse and get enriched by the end of the day. Thank you so much.
Hello, good morning, everyone. Here in Europe it's 7 o'clock, so it's rather early Saturday morning. But nevertheless, thank you so much for the invitation. And thank you also for giving me such an honor to be one of the first people to address such a prominent and, let's say, well-structured conference and event itself. Of course, C-19 or COVID, as known, has marked us in many ways in the past, let's say, 15 months or nearly 1.5 years. So it's very difficult to, let's say, to find the field of human activity, be it social, political, economic, and the like, that does not touch upon the, let's say, a change that has been impacted by the COVID. So of course, civil aviation is one of the hardest hit areas, as we all know. Tourism used to be a very promising branch, and it was fastly booming in the past decades, and especially in the past years. And civil aviation is an essential part, as we all know, of the tourism industry. I have witnessed myself also that Asia was passing the unprecedented boom and the arrival of the middle class, which has been, of course, pretty much a renaissance for the civil aviation. I saw all over Asia new airports, new airlines. One of the most, let's say, fastly expanding networks known as AirAsia even had the slogan, now everybody can fly. And this was really remarkable. So practically people were getting connected not only in the compact countries which are having the land corridor, but also with the archipelago countries like the Philippines, Indonesia, Malaysia, and many other countries of Asia, which meant basically a simplification of life, better communication, so practically changing the way of life in many of the countries of Asia, but not only of Asia. And the flights were really getting very cheap, very accessible to everyone, and something that already by 60s or 70s was exclusive, let's say, privilege of the upper class became basically a standard norm. People were flying, and even on the shorter destinations, simply flying, for example, in Europe, where even the living standards are higher, people rather opted for flying than for let's say, going by car or by train, because it was considerably cheaper. For example, trip from Vienna to London by plane, by Ryanair or German Wings, the low-cost carriers, was between 25 and 40 euros. So practically even students with a very, let's say, restricted budget were able to just jump for a weekend to London and to spend some lovely time with the friends, or let's say friends from the country, or friends that flew together with them for some time. So practically it was a way of life, not only of the tourism industry, that affected civil aviation. And then with the COVID, of course, the first moment was a shock, in which practically we all been advised to go into the quarantine. And that interrupted very sharply the way how we've been conducting our everyday lives and how we consumed our holidays. So simply everything has changed. And now we have situation as it is. What we are mostly told is that practically we have one major illness and one major cure to this. And then in a subtle way, also civil aviation has been let's say, invited or pressured to be part of the solution, and solution has been offered only by injecting certain substances as to prevent the disease. So there are a couple of steps which we have for sure to reconsider and to, let's say, give a second thought and see the long-term perspective. So safety and security should never be on expenses of human rights. The same goes with the health. So it should never go on expenses of human rights. And this is a trap that civil aviation, like some other industries, should not actually be a victim of. So this is very important to understand, that practically informed consent, the right for the second opinion, is an elementary part of the right to health, and the right to health is a constitutional right. So altogether, before requesting certain, let's say, prerogatives or let's say um, preconditions in order to fly with the civil aviation, we have to go back to the Charter of United Nations and also to the fundamental instruments that have created so-called international legal regime of civil aviation or of aviation altogether, which goes back to the Chicago and to the Warsaw Convention and to the very formation of one of the specialized agencies, as you well all know. It's a civil aviation organization, which is the specialized agency of United Nations system. So it's one of the constituting parts of the family of United Nations. So it's not directly under it's not directly under the Secretariat of the United Nations system, but it's one of the specialized agencies. So this is very important. Whatever moves we have, so not to get lost in the technicalities, but whatever moves we are about to conceive and let's say conduct and accept for the civil aviation, the first and most important thing is always to give, let's say, the interpretation in the spirit of the Charter of United Nations, Human Rights Charter, and then to the basic conventions of civil aviation that created the entire regime and institutionalized this as an organization, as you all know, that has its headquarters and has its place also within the family of United Nations. United Nations is not the perfect system, but is the system that conducts overall affairs of our globe. So as we are imperfect, as our relations, international relations, you know, and overall conduct of international relations is imperfect and full of imbalances, full of atrocities, full of misconduct, full of, let's say, suspicious and suspectful activities. So this is our system, because we can't have a perfect system which we have created. So system reflects actually, let's say, the picture that we are all creating in today's world. So this is the most important part, because what is happening is that actually certain activities or certain pressure to go one or the other direction is imposed also on the carriers, on the civil aviation segment as a regulator, but also on the companies that are actually carriers. So meaning actually, unless you are let's say subject of injection, you are given or you are not given permission to fly. I think this is a trap, and this is something which on a long-term consequences should be taken and considered very much. So the civil aviation cannot be part of the coercive mechanism of state. This is very important. So I think this should be a bottom line. Why? Because civil aviation depends on people. So if people do not want to fly, then the carriers and also the civil aviation as a regulator would be actually having a trouble. So in the long run, it should be sided up with those people who are basically feeding the whole system. So that's I think the most important thing, not to get lost into the technicalities and certain, let's say, implementation. This is a segment which suffered a lot, and this is a segment which will only recover if supported basically by the customers, by consumers. So it's not, let's say, that probable that the civil aviation or tourism industry would fetch up that easily. So that's something that we have to take let's say very much into the consideration. And what is very important when we talk about public health is an issue for each and every of us. On question of public health, we all have a say. You know, within the European Union, here in Europe, you know, we are funny people because we love institutions. We are the most multilateralized region of the world. we are practically members of so many different institutions, especially European one, the regional institutions. And then very often, when a country signals to join a certain club, then we are promulgating it via parliament, or we are setting up referendum. And frankly, if the country would join EFTA, certain, let's say, economic and tariff and trades related grouping, this is a little bit structured question, and I'm not sure. I'm not telling it's not a question for the direct democracy, which is a referenda, but I'm not sure that such a structured question could be easily answered by each and every subject of society. If you would like to have a PTT or TTT or whatever acronyms of the trade deals are, so I'm not always sure, whether each and every, whether my grandy neighbor could be understanding and comprehending what does it mean to join or not to join. If Austria joins with Germany, some trade deal with Canada, with Japan, with India, and this and that, so it's a little bit structured question. So maybe some of those questions should be not considered and decided on, resolved on referendum, which is, as known, the most democratic way of direct democracy. So that means that every single citizen decides, votes for something, gives his or her voice. But when it comes to questions of public health, it cannot be decided in a, let's say, in a narrow circles of the executive branch. This is impossible, this is not acceptable, and on the long run, it would fight back. And what is very important is that basically civil aviation does not become a problem, but remains solution. So this is very, very important, and that's my main message this morning to say. So we should not go into this trap and become part of the coercive mechanism. And we cannot compromise safety and security for health, because on a long run, we will lose both. As simple as that. And history is full of examples, I usually say you can beat me, you can call me whatever names, but you cannot beat history, so you can't change the history. And history is full of examples when we thought, when there were critical crossroads, and when we decided actually to compromise our human rights, when we said maybe little coercion, maybe little pressure on individuals would help. We in Europe, we are especially full of such examples. Look at the First World War, look at the Second World War, look at the decades of the Cold War, how it looked like. When we had an impression, okay, we are in the very hard and exceptional times, so let's compromise a bit of our human rights and we will achieve this and that. So this is very important that we are not getting. Public health is a private choice. Public health is an issue for everyone, and it can't be decreed by the alienated group of the executive branch, which has been never elected and never checked. This is the most important part to say. And everything what we do in relation to COVID, to C-19, has to be interpreted first and most of all, before we go into technicalities, should be interpreted in a spirit of the Charter, of United Nations Charter, because this is the evolutionary peak when we really humanized ourselves in the 45. When we Homo sapiens really became humans, and when we elevated also, we lifted humans, individuals, as a subject of international law. So just to remind those of you who are not, lawyers, subjects of international law are states, international organizations, and individuals. So we have same level. State and individual has the same level. The moment when we give up from this, we gave up from so many things. This is something that we have to forget, not to forget. So anything that relates civil aviation to C-19 should be interpreted first and most of all with the Charter of United Nations, Charter of Human Rights, the Universal Charter of Human Rights, and then with fundamental instruments that created international aviation regime, so Chicago and Warsaw, because we had a large and overall comprehensive agreement on this of all states, of all stakeholders, and of all states and societies at that time when we created it and we accepted. And then we come to everything, and of course, the right to health should not be compromised by the, let's say, by the ideas of the Prophet and so on and so forth. So this is from my side, because I see the time is ticking, and that today is a very promising program, so I don't want to take, let's say, more of your time. Once more, thank to organizers for excellent event, and to all of you for let's say being together this morning, this European morning. Thank you so much.
Thank you very much. Good morning, everyone. On behalf of Professor Anna Konert and myself, I would like to present you a few slides dedicated for Polish regulations in terms of air law related to coronavirus. More wide comments we will publish in our article. So starting from the beginning, in Poland in March 2020, epidemic threat was announced, followed by epidemic in connection with spread out of infection diseases, and this disease is known as a SARS-CoV-2, known as a COVID-19, as everybody knows. And as in other countries, also in Poland, there have been actions that limit possibility of discharge movement of people. They affected aviation, of course, and international transport in this first place, but also severe restrictions on domestic public transport. In terms of, because Poland, as you know, is a European Union country, one of example for changing air law regulation due to COVID-19 in Poland as part of European Union is airport slots requirement. As part of overall European Union slot requirement, airlines must use at least 80% of their slots in order to be able to keep them for the following year. And due to COVID-19 pandemic, there was a special dedicated regulations that airlines, they may have returned 50% of their slots series before start the 2021 summer season. And those airlines will have to use at least 50% of remaining ones if they want to keep those slots. On 23rd July 2021, European Commission proposed to amend slot regulation and extend these slot relief rules adapt in February this year, 2021. As aviation industry starts to recover from impact of COVID-19 crisis, European Commission remains committed to continuing relief from normal slot allocation rules for airlines within Europe. Relief therefore will be extended to coming winter season, which will be running from 31st October 2021 until 27th March 2022. So instead of normal requirement, as I mentioned, to use at least 80% of given slot series, to retain historic rights in those slots, airlines will only have to use 50% of given slots. The other example of regulations dedicated for COVID-19 was regulations dedicated for validity of aviation certificates, licenses and permits for aviation crews, for companies, airlines. So according to this, for example, Polish CAA, as a part of EASA, European Safety Agency, approved dedicated procedure establishing specified interim measures to view persistence of COVID-19 crisis regarding renewal of extension of certain aviation certificates, also licenses and approvals postponed for certain periodic inspection and periodic aviation trainings. Another regulation, example of regulation as a European Union aviation safety, this organization, and we implement this regulation within Poland. This agency published also safety information bulletin containing operational recommendation related to vaccination for all the crews, for aviation crews. EASA also published guidelines for return to service of aircraft from storage in relation to COVID-19 pandemic, because as you know, a lot of aircraft was grounded, majority actually was grounded. So there was special regulation also implemented in Poland in terms of return those aircraft to service in order to support safe return to normal operations and to supplement already published frequent asked questions continuing airworthiness of such aircraft. EASA also developed guidelines for de-storage such aircraft with support of industry and national competent authorities. This document raises awareness of possible hazards and suggests mitigations following potential risks of aircraft returning to service after storage. Also, this document emphasizing the need to consider particularities of each case and communication with relevant organizations and competent authorities. Also, EASA updates safety directives for cleaning and disinfection of aircraft due to pandemic COVID-19. This regulation also was implemented in Poland. So European Union Aviation Safety Agency issued updates to safety directives relating to cleaning and disinfection of aircraft for operations in current stage of COVID-19 pandemic. This update, there was a dedicated number, are based on assessment of evidence and data collected during past year as well as the current epidemiological situation. Safety directives mandate operators to fully clean and disinfect aircraft at least once every 7 days or more frequently, if of course will be needed, on basis of operators' risk assessment based on incident rates in accordance with criteria set in Council recommendation. There is a special dedicated number for this recommendation, as last updated, and variants of concerns circulation in territories where this aircraft is to operate. The risk assessment should also take account of other mitigation measures in place. For example, mandatory negative testing before boarding, use of vaccination, etc., etc., and certificates in the form, for example, of digital COVID certificate or equivalent of such document or application, duration of disinfection effects of substance used. Additional law procedure that is during implementation, also of course within European Union, but also in Poland, is European Union COVID-19 digital certificate for vaccinated citizens. This certificate will facilitate safe movement of people within European Union during pandemic. Certificate will be introduced in all member states, European Union member states. Individual countries, including our country, Poland, can now start issuing and using such certificate. In June 2021, European Union Aviation Safety Agency and European Center for Disease Prevention issued new version of aviation health safety protocol, providing clear operational guidance and risk-based recommendation for health-safe air travel, complement the European Union initiatives such this European Union digital COVID certificates. New version of document take into account new evidence and information as circulation of variants, Delta, Alpha of coronavirus, and roll out COVID vaccination also programs. New version also emphasizes need to keep non-pharmaceutical measures in place, such wearing of medical face masks, physical distancing, and other conditions. It is intended to provide support to national authorities in the member states and to aviation stakeholders, and is based on latest scientific evidence, epidemiological situation, and policy development. In line with current scientific evidence and the European Council recommendation, there is a protocol that is proposed that people who are fully vaccinated against COVID-19 or who recovered from disease in the last 180 days should not be subject to testing or quarantine unless they are coming from area of very high risk or where appropriate variant of concern is circulating. For travel from such destinations, requirement for for negative test could be also considered. This could be either a rapid antigen detection test taken no more than 48 hours before arrival, or PCR test that will be done no more than 7 to 72 hours before arrival. Also, use of passenger locator forms application to facilitate contact tracing is still considered as a very important tool as well. In addition, physical distancing, of course, of at least 1 meter must be maintained, and medical mask must be worn at all stages of journey for passengers, for crews. Also, hand and respiratory hygiene measures also need to be observed. All those measures are recommended for European Union air travel, but also for air travel to and from third countries. In addition, to ensure safe travel by plane during coronavirus pandemic, European Union provides map on which European Union countries are marked in accordance with traffic light system according to coronavirus infection rates. Website also provides information on entry conditions and applicable restrictions and special requirements like, for example, quarantine and testing. And this is the example on this slide of this map. Of course, this is the live map. Maps in support of Council recommendation on coordinated approach to travel measures in European Union. These maps are published by European Centre for Disease Prevention and Control. This is the agency of European Union. Every Thursday in support of Council recommendation on coordinated approach to restriction of free movement in response to pandemic COVID-19, which was adopted by European member states starting from 13 October 2020 and Amendment 28 on 28 January 2021 and 14 June, last update 2021. The maps are based on data reported by European Union member states to European surveillance system, as I mentioned, every Tuesday. And COVID-19 vaccine tracker. This is the also live website which is provided to all countries within European Union. Information presented in this vaccine tracker, as you see on this slide, is based on data reported by European Union countries to European surveillance system as well. European Union countries may upload data at any time, but as minimum they are requested to report twice a week. Usually it's Tuesdays. Data in this tracker are refreshed every Monday and Friday. And of course, we as a Polish citizens, we can use this website as well. So I would like to thank you very much for your attention. As I mentioned, much more wider presentation will be provided in our article. Thank you very much.
Okay, thank you very much, Shubik, for the introduction. I would like to first, before I begin with my presentation, say thank you to the Center for Aviation and Space Laws for the invitation, as well as to the National University of Juridical Sciences, and of course, Dr. Cindy Babat. I will be presenting on COVID-19 impacts. However, my paper is actually different that I will be submitting for this conference. And let me go to my next slide. It's actually better pandemic regulation and the Philippine air transport industry, systemic challenges and prospects. So unlike, for example, the EU, where the interest really is on human rights, and of course for Poland, it's complying with regulations of the EU, the Philippine regulation of the airline industry or the aviation industry at this time is very much centered, focused only on the Philippines, and of course coordinating with other countries. So my paper really looks into smart regulation because that's where we lack capability or capacity on. For example, the EU has a very sophisticated online and real-time system for managing the crisis, while the Philippines basically have to do with sort of a hybrid manual and as well as online and real-time management system. So I will be talking about, for this presentation today, I will talk about how the Philippines transposes ICAO rules on pandemic regulation into Philippine law. And then I will give a very brief update on the COVID state in the Philippines. I will then go into the regulations that the Philippines have passed during the 2-year period, 1.5-year period, and then of course looking into COVID impacts and concluding. So let me now, sorry. I hope you are able to see the screen. Yes. Okay. Thank you. So let me now go into the Chicago Convention. Sandeep has already talked about this, so I will just really gloss over and really just state that there are 4 obligations under the Chicago Convention, which Sandeep has already talked about, and this has to do with ensuring compliance with quarantine measures by the state, and then of course the obligation to ensure the prevention and spread of disease, and in this case COVID-19, and then of course the duty to harmonize our regulations with those of to the highest degree possible, and to facilitate and prevent unnecessary delays in passenger, crew, aircraft, as well as cargo. And of course, the other supplementing regulations for this are, of course, the World Health 2005 regulations, and the WHO has guidelines to hygiene and sanitation in aviation, and the Philippines, for example, has really complied with those guidelines. So in terms of how the Philippines transposes this into operational standards in the domestic sphere of aviation, you will find, for example, that our regulatory system in the Philippines is really quite stable. We are parties to 5 treaties only in regard to civil aviation, and our regulatory framework in terms of legislation, we only have 3. It took us 50 years to amend our system, so to speak. That was back in 2008, and it took us another 4 years back in 2012 to also issue our Bill of Rights for air passengers and carrier obligations. However, in terms of translating our ICAO rules and standards, for example, operational standards and recommendations, we are quite quick in doing that. So our Civil Aviation Authority of the Philippines, through the CAAP Regulatory Standards and Development Division, is really quite quick. It takes only around 18 days, even for highly complex and highly technical regulations from the civil aviation, from the ICAO in this case. So moving into how then have the Philippines coped with the crisis. So, for example, in early February 2020, the WHO was very quick to actually advise states to immediately, at the highest level, activate the national response management protocols. And at the time, they weren't really recommending travel restrictions. However, by August, there was a sort of a weakening of this policy, and they now allowed WHO recognize that that states have the right to actually apply travel restrictions. So in the Philippines, this is actually how we created our structure in terms of addressing the COVID pandemic. And of course, this is very similar to almost all developing countries around the world, where we applied a whole of country approach also. So Vietnam, Indonesia also has this. So we have quite a large task force for the management of emerging infectious diseases. And we also have a dedicated task force on COVID-19. And this is led by the Department of Health. And of course, our approach is twofold. We want to limit community transmission. So we have controls in regard to community transmissions, and we have 3 types of lockdown. And currently, Metro Manila, for example, is in the red phase, where limits to travel is actually the travel of airlines is actually very limited. So there are no flights except essential flights within the country from Metro Manila to other parts of the country as well. And of course, our schools and government services are actually maintained on a skeletal force. And this is true for all, and it really depends on the level of and unit of government, whether they recommend they want to be under the ECQ system or a modified enhanced community quarantine arrangement, or currently most provinces around the world, around the Philippines, are actually on the general community quarantine, where there is some movement allowed, as well as most of our essential services are actually open. So in regard to border controls, I think for us, what really is quite problematic is the arrival, which is limited to 2,000 passengers per day. And of course, the Philippines has a very large diaspora. We are around 10 to 12 million around the world. And so there is really high demand for travel into the Philippines. And of course, human rights issues come into play. However, as Dr. Anis noted, that this is probably not going to be allowed, for example, in Europe, and there would be a lot of objections to it. But in the Philippines, the executive branch of government is actually controlling through the interagency task force, controlling the number of passenger arrivals into the country. So in terms of our situation, and really this goes back to the issue of the World Health Organization's advice against travel, you will find I have shown here 3 countries that have actually, in the ASEAN, that have actually imposed quite different travel restrictions. For example, Vietnam has a very strict travel scheme. They actually started very early. The Philippines sort of waivers, and of course, from time to time we go into very strict arrival of passengers, for example, very regulated entry into the country, while Indonesia, for example, has maintained its assertion that travel should be free in and out of the country. But of course, not all travelers, essential travelers and those who have rights under the human rights, the right to return to their countries, particularly those who have their work permits, for example, those are allowed in Indonesia. So however, you will find, for example, that for Vietnam, they have not been able to contain their number of community transmission. So even if they started really very early, and the Philippines started a bit late, around 3 months later, but nevertheless, in terms of our really strict protocols, but nevertheless, you will find that we are almost at par in terms of the new cases per week. So we only have around 4,000 cases more, active cases, than that of Vietnam. And in terms also of the death rate, we have quite a low death rate. So that really shows that it's not really the travel, air travel, that's really poses the greatest risk in terms of COVID transmission, but actually community transmission. So in terms of the regulations that we have had over the past 16 months dealing with the pandemic, the concern for the Philippines are really just 2. We have passenger services and travel facilitation, and we have our omnibus guidelines that actually still restrict entry of the general public and foreigners traveling to the country, only essential travel. And of course, there is a problem with the vaccination passports issue, because the Philippines, nevertheless, even if an individual is fully vaccinated, still requires that the passengers still be subjected to the 14-day quarantine, 10 days quarantine in a facility approved by the government, and another 4 days after the PCR test on the 7th day is actually is shown to be negative. Then the individual flies to the final destination and must quarantine for another 4 days. So that's a very big issue in the Philippines in regard to those individuals who have been vaccinated already. Now, in terms of air transport industry support, we basically we're quite slow again in terms of our support to the industry. We basically have no dedicated scheme for the airline industry. What we have is one provision that goes into that allows and removes the power to review for mergers, actually by the Philippine Competition Commission, foreseeing that there might be industries or airlines that might restructure and might be absorbed by other airlines or by the government. So any mergers that in regard to the amount of $1 billion will be allowed to and will not be subjected to review, and this will be effective until 19 December in 2022. That's less than 1 year, so a very short span of time. And this law has lapsed, so we do not have a law now currently. So we have one pending in the Senate, and in that bill there is a proposal for a 1.4 bailout for the transport industry, but that still hangs in the balance. So that leads me now to the COVID impacts. So the Philippine air transport industry is a fast-growing one. So that means in terms of our predicted numbers by 2037, we are expected to more than triple our passenger flow into the country. But as of now, you will see that our domestic scheduled air services is depressed also, as is in most countries around the world, around 77 to 80%, as well as the international scheduled air services as well. So this leads me now to the issue of financial assistance for our air transport industry. Again, they have been clamoring for support, and they said that they would need around 172 million injection per month for the 3 airlines to actually operate, and this 80% of that would go to aircraft leases and payments, and then we have 15% wages, and then for air transport navigation, that would be around 5%. And much of these have been waived in the past year. So, and for sure they continue to be waived until now. And our government has, of course, also committed to help the airlines tide over, and they have been able to do that by assisting our 2 largest airlines in the Philippines, the Cebu Pacific Airlines and the Philippine Airlines. So I would now like to conclude very briefly. Really in terms of response to public emergencies of international health concern, swift action is necessary. However, to prevent the importation of the virus and its containment. However, over time, gains that we might have from quick action actually may be lost if community transmission is not actually contained, as is the case of Vietnam. And in terms of the air transport industry in the Philippines, there really needs to be much improvement in terms of regulatory impact assessments, and we need to address resource, technology, and human capital gaps, and we need to make more public investments in IT infrastructure, data analytics, for example, because there's a problem with information dissemination in our country. But we're coping very well with the COVID-19, given the fact that we are a developing nation. So that's it for me. So thank you very much for your time and for listening. So thank you.
Yeah, before you, during that time, I would like to say thanks to Professor Sandeepa invited me for this meeting. I am very happy to talk about a very interesting issue, and I try to put it in the very complex situation. I really hope you will enjoy the presentation because I will try to approach this issue in a different view, and not only talking about COVID-19, but also the other diseases, which is also in the case that we are facing with now with the COVID-19, but there are plenty of other diseases and problems which affected the aviation industry in the past and will affect it in the future as well. Thank you. All right. The title is the main theme is very obvious: aviation industry and the public health norms, the road behind and ahead, and the challenge of security, which is not a joke. It is a real situation, a real problem, and I'm going to talk about this issue. Of course, I divided three parts of the presentation. The Chicago Convention, we have to talk about Chicago Convention. This is mandatory. That is contains a lot of regulations, and not even the Chicago Convention, but its annexes also full with regulations, standards, and recommended practices in regards of the health of passengers, and also not even the health of passengers, but also the action which has to be taken by the crew, the ground staff, and the other staff who are serving the aviation industry. Also, Montreal Convention. It's also crucially important to mention who is liable if something happening, and this liability issue is always on the table. It's not if something happening, always something happening, and that is the case. And also, I would like to speak at the end of the unified regulations, how we can manage this very complex issue, although it has managed in many ways by World Health Organization, ICAO, the national law, different systems, even the EU, but they are not unified. They have a lot of differences and create a little bit more problems than solution in many ways. So the first slide, of course, I summarized what is the, please go ahead, if it's possible. So the first slide summarized what is the regulation right now? What is which help us to understand from a legal point of view what is going on? Of course, the air transport has a crucial role in the worldwide spread of diseases. It is obvious. It was known in the beginning. It is not started today. Everybody remember for the influenza pandemic situation in 1918 and after in 1958. So there were a lot of pandemic situation in the 20th century as well, and lots of hundreds of thousands of people died, which we have to treat seriously. If you look at the Chicago Convention, in the morning, Professor Sandeepa mentioned Article 9b, which is also very important, the prohibition area, but also we have to highlight the Article 8.13, which is the entry and clearance of the regulations, Article 14, the prevention of spread of these diseases, and also the facilitation of formalities, Article 22. The Chicago Convention, Article 14 is one of the most important sentences for us. As I mentioned, this influenza pandemic situation happened 3 times, which was seriously affected the mankind. But we, as you can see, the Article 14 is mentioned few of the diseases and other communicable diseases, but also it has been known later on in the history, the SARS, for instance, the serious acute reciprocity syndrome, or the familiar name of this pneumonia of type of A problem. A lot of people died. A lot of action has done by World Health Organization and ICAO, and also of course the H5N1 avian influenza, the swine influenza later, the MERS COVID, and also another avian influenza, as you can see, the Ebola, and now SARS-CoV-2, which created this COVID-19 disease. If you can see the SARS, and also if you can see the Middle Eastern respiratory coronavirus in 2012, they are all coronaviruses. So that's nothing brand new for the mankind. That happened 20 years ago or 10 years ago, affected, but nothing serious happened. That's why we are not facing the serious as we are facing nowadays in the last 1.5 years. But their diseases are close to us. We are living with this pandemic situation from a long time. And also, as it mentioned, the first sentence, air transport has a crucial role, and that's why the Chicago Convention and also its annexes. If you look at Annex 6, which is one of the most important annexes, mainly standard annexes, there is a section about the medical supplies, the cabin crew training, how to treat the situation, how to handle the situation, and also some first aid training in regards of these diseases. The facilitation Annex 9 also contains a section about communicable disease outbreak, as you can see, as you can read it, or also the aircraft descent section, and also these infections, and also in Chicago Convention mentioned which kind of documentations you have to carry on board, and also this kind of certificates, vaccination certificates, disinfection certificates, and other certificates you have to carry on, and the foreign and also the aviation authority can check it carefully. Not only even the pilot license, not even the airworthiness certificates, the air operative certificates, and the other most important documents, but also these documents also carefully investigated by the civil aviation authorities worldwide. Also, if you look at Annex 11, 14, 15, and 18, you can see many annexes contains serious rules, regulations, standards, and recommended practices in regards how to treat the situation if it affected the aviation on board and on the ground. Okay, so Chicago Convention, a little bit, we have to jump into a little bit. Professor Sandeep was asking, where is the law? Where is the law? There is the law here, but the question is not where is the law. I guess I think what have we done since the Chicago Convention was signed until 11 March 2020. 11 March 2020, when the World Health Organization officially announced that there is a disease and the pandemic situation worldwide. That's why I put into this data into my presentation. ICAO and other specialized institutions, mainly World Health Organization, and also the CAPSCA and the FAO and UN WTO, they have done a lot of actions. Just the examples, when SARS was introduced in 2003, they have allowed, legally of course, to refuse a passenger to get on board, even the passenger has valid air ticket to travel if the passenger was infected by the virus. Also, it was mandatory to inform the passengers about the conditions, how to behave, what kind of paper is necessary, what you have to do if you realize you have some problems, or the other passenger has a special problem. And we called about, of course, the infect, just to make safer the aviation. Also, there was a further health screening was possible. The crew had a training how to separate the passengers, and also the ground handling staff was trained how to welcome this passenger, and also how to sterilize the cabin after this situation. So there were a lot of things they have done, of course. Also, there was everybody knows there was a camera system because they measured the body temperatures of the passengers. Of course, they have a special procedure. And finally, the latest procedure, which was introduced by ICAO and how to close the airport if it's necessary. So that was everything on the table. There was a lot of rules, but what have we done? We have done a lot, but not enough. Why? If you look at this Hawaii, if you look at the Hawaii State Department report in 1994, which was presented by WHO, 7 cases in 1998, there was few very interesting situations which happened, but the industry didn't react immediately. The industry didn't thinking prevently. They need to have this SARS, this COVID-19 situation, because if you look at the developments of the aviation industry, you can see doesn't matter the oil crisis, the September 11, the financial crisis. A lot of crises hit the industry, but after a few months or very short period of time, it's recovered and start growing and always growing, and even the regulatory makers and even the industry players, they haven't paid much more attention to these situations because it's solved. The industry is going on, the profit is, we are safe, we are secured, and or more secured after September 11, of course, and everybody was happy, and they haven't done preventive actions just to avoid the diseases or that kind of impact of the diseases, although the Chicago Convention mentioned how we have to react or how to act in this regard. So the Hawaii State Department story was very, very interesting. The lady traveling from Honolulu to Chicago and from Chicago to Baltimore, only Honolulu and Chicago flight 8 hours, and the lady was infected by the tuberculosis, and the lady died after this trip, and it was a huge investigation, and the investigators found the lady just had met minimum 900 passengers during her flights. Of course, she infected other passengers as well, but they were symptom-free. They just realized during the investigation. But the interesting thing in this regard is it is not an Ebola virus. It is much more, because Ebola virus, if somebody is sitting next to you on the plane with HIV positive or the Ebola virus person, you don't need to be scared. Nothing will happen. But if somebody is sitting next to you or close to you with tuberculosis, it is a danger. It's a danger because it is this multi-resistant tuberculosis, MDR, TB, as I mentioned there. It spreads quietly, insidiously, primarily via droplet infection. So droplet infection means coughing, maybe smiling, I don't know, but smiling, but it's possible, speaking one another or next to each other, sneezing. So it is very easy to spread and infect the others. And that was a huge danger. And it can create a serious pandemic effect worldwide, and also a serious effect for the aviation. But no one done much, of course, although the World Health Organization presented the report, and the industry didn't react because it was solved somehow. It wasn't create a serious worldwide problem. Like Ebola virus was, for instance, was treated professionally when they realized, of course, the Ebola virus just spread over immediately from Africa to United States, to Canada, and other part of it, to Asia, other part of the world within 24 hours when they realized, because of the aviation, of course, but they somehow solve this issue efficiently and also very pragmatic approach. So it wasn't a serious problem which we are facing nowadays with this COVID-19. Okay, there is another very interesting case, the Diaz versus Trans-Brazil Airlines case. It was Professor Sandapi mentioned this case 1 year ago and highlighted to my mind. it is not a Chicago Convention, of course, because it's a Warsaw Convention and the Montreal Convention. It was treated this case by the Warsaw Convention, but it is also, we have to put here in this context, because the person who died in pneumonia, the plaintiff went to the court, sued the airline, and according to the court, it was an accident because this kind of disease was the death of the passenger was the result of the poor quality of the aircraft cabin air. So they have found a relation with the flying activity and also the accident which happened. So this flight from Brazil to New York, it was a long flight, and because of the cabin air wasn't proper, it was caused or developed, is better word, the fatal reciprocity disease, and the passenger died. The court qualified this issue as an accident. So that is very serious, because that was the first case, and also the industry hasn't found a serious threat in this regard. That was a story, and it was solved. The plaintiff won the case, and that's all. So what we have done, not much, not even the regulatory, but also not even the practical, the pragmatic approach. Yes, Montreal Convention. We are in Montreal Convention annually. I think you know, more than 1,000 passengers died on board on the aircraft. Of course, it was in 2018 the statistics. The question is it accident? That is, or are they accidents? That is the main question. Mainly, they are not accident, of course. They are not accident. If you look at what does accident mean, according to the Montreal Convention, Article 17, Para 1, the accident is unexpected or unusual, unforeseeable event or occurrence related to the activity of flying and external to the passenger, owing to which the claimant dies or gets bodily injured. They are the main the definition of the accident, and they found this Diaz case as accident, but mainly in civil aviation. Of course, the diseases or the state of health of the passenger, the condition of the health of the passenger is not create accident. It needs to have much more. Like in this regard, like in the Diaz case, the passenger was sick during the travel, of course. He died at the end, but they have found a link with the poor quality of the cabin air and with her sickness. So that's why they treat it as an accident. But mainly in civil aviation, and we can go to the another slide. Mainly in civil aviation, there are plenty of actions happened on board in regards of the condition of the health of the passenger, and they are not treated as an accident. Look at the other slide, please. Yes, look at the baggage, the sprain or the strain owing, not a big deal during the packing of hand luggage, or the problems deriving the catering, that is which create a food allergy. So also it has a link with the passenger health, and also any event which has deriving from the disease or state of health of the passenger. Physical problem, I mean mental problem, emotional problems, fears, that kind of things also not created an accident or not treated as accident according to the Montreal Convention. So the airline is protected very well. The airline feels what he can do. He cannot do much because the crew are not medically trained people. Of course, they have some special training. Of course, they have special equipment, but they are not trained as a nurse or as a medical staff, and that's the reason they are not liable or they are not responsible of the state health of the passenger. This is our responsibility. We know only what is our disease, what is our problem, what we can do, and we are responsible. Do we fly or not? Or not also we, but our doctor as well can ask advices. How protected the airline?
Professor Sipos,
Yes?
sorry to interrupt you. You have another 2 to 3 minutes to wrap up, sir.
Yes. Oh, it's okay. And I see. I am in time. Yes, please continue. Yes, the question was COVID-19. Yes, COVID-19 is a health issue is not qualified as an accident. Everybody is now relaxed, especially airlines. They are the key player of the industry. They have to be recovered. They make the profit. They make the money. They make stronger the airports, the air navigation service providers, the cargo, the ground handlings, and the other stuff. So airline has to be recovered, but airline is safe situation because they have no responsibility and liability if the state of the health of the passenger. But there are few situations when they can found it, like in the Diaz case. It was summarized by myself. You can see in the 4 points. If there is a link, of course, with a crew activity, negligence, if there is a technical failure, altogether, there is, of course, a situation when we can treat this COVID-19 situation as an accident. Next slide, please. Yes, the airlines are protected by that they have the general condition of carriage, which contains how to treat those persons who are special needs. Also, they can prohibit it to travel on the air if the conditions are not met with the safety or secure conditions. So the airline has a lot of tools how to manage to travel, because aviation is open for everyone. We cannot make distinction passenger, health passenger or not health passenger. Everybody is the same and treated properly, of course, according to the law and according to also the general conditions of the carriage. But also, it includes 2 stages mentioned. Next slide, please. And next one again. Yes. No. It has the last one, please, because of the time. Okay. Yes, this one is okay. Also, I summarized what kind of regulation do we have. But these regulations are mainly advising recommendations and not internationally accepted rules. That's why we need to have more regulations, more measures, more joint forces and trust. The only player who can provide us ICAO. ICAO has 193 member states. They have a power and they have enough knowledge and experience to do it. I urge the future is the SARPs, standards and recommended practices. If we would like the security situation solved, we need to have another annexes which just combine and also as a standard dealing in worldwide and can solve this issue which we are facing nowadays in regulatory point of view. Thank you for your attention, and I enjoyed the time together.
So, very good afternoon, everyone. Before I start my presentation, my compliments to the organizing team under the leadership of Professor Sandeepa for conceiving a conference and the deliberations on such a contemporary concern for aviation law. And I also thank him for trusting me with this presentation. Thank you. This presentation is about concerns relating to public health and aviation. The presentation scheme is as follows. So aviation and public health, the intricate relationship, and you cannot ignore in this relationship the economic and financial aspects of it, and then measures taken internationally and specifically in Indian context, and what kind of challenges are foreseen ahead. When it comes to international challenges, Professor Attila has already spoken extensively about the international scenario, so I will not delve much into it. Next slide, please. Now, when we look at public health, it is seen as the art and science of preventing disease, prolonging life, and promoting health through the organized efforts of the society. What we look at very specifically is the entire spectrum of health and well-being, not only the eradication of particular diseases, although when I make this presentation, the context is a particular disease. Now, next slide, please. COVID-19 comes up as a challenge with a lot of peculiarities. We are aware of all these things when it was first reported, and then how it was titled the way it is titled, and then it is declared pandemic. A lot of concerns that it took a lot of time for the WHO to actually declare it as pandemic. Eventually, we losing a lot of time in that. But a very important aspect that we must not ignore with regard to COVID-19 is the prophylaxis. Even the medical community has been uncertain as to how this virus is going to behave and what kind of consequences this virus is going to lead to in terms of public health. So therefore, our responses generally with regard to COVID-19 and specifically in the context of aviation has shown an evolving trend. As we researched more about this virus and the kind of characteristics it shows, our regulations also evolved simultaneously. And when it comes to implementation, that has been a challenge as I see it. But this is very crucial aspect with regard to this. Next slide, please. Now, when we look at aviation, actually, we look at it fundamentally in terms of aircraft, but then airport plays a huge role. And then it is a continuum. What happens to us or what's happening to us before we reach to the airport and what happens after we move out of the airport. It's all a continuum, and that's how it is to be looked at. And the regulations relating to aviation actually acknowledges in many situations this continuum. Multiple stakeholders are involved. Few I have mentioned in the slide, but there are others as well. So crew is there, obviously, passengers are there. Again, obviously, security personnel deployed on the airport and ground staff. So a lot of stakeholders, they interact together, and we realize the significance of this interaction, particularly in COVID-19. When it comes to what kind of ventilation mechanisms we have a very specific ventilation mechanism for aircraft, and we have the same for airports. However, in terms of quality, it varies. In terms of effectivity, also it varies, and COVID-19 experience did indicate that. May we move to the next slide, please? Thank you. Chicago Convention is referred. Professor Sandeepa has provided the context for it in the very opening remarks. So complete and exclusive sovereignty in Article 1, and then Article 13 talking about quarantine requirements. And then you have Article 9, to which a reference was made in the inauguration session itself with regard to some temporary measures that can be taken. And then Article 14, next slide, please. Where you have made reference to such other communicable diseases, to which Professor Attila has already made reference, so I'm not elaborating on it. A few diseases are specifically mentioned. I'm sure this experience will necessitate a rethink with regard to whether we need to add to this list. And nevertheless, such other communicable diseases clause does include this kind of a concern. And as Professor Attila pointed out at the end, do we need, next slide please, do we need an extra 20? I mean, that was a very interesting point. SRPs relevant to Article 14. So Annex 6, 9, 11, 14, 18. They do talk about concerns which we have faced with regard to COVID-19. Very interesting is its implementation in aviation law, and there are a lot of concerns with regard to what kind of implementation characteristic it has, whether it is soft law or a hard law. That debate apart, we have seen as to how significant it is when it comes to implementation and preventing people from diseases, particularly in the context of public health, when it comes to COVID-19 crisis. Next slide, please. Now, ICAO, as Professor Sandeepa pointed out in the beginning, works in close collaboration with WHO, IATA, and Airport Council International. So that collaborative approach is very important, and we have seen as to what kind of difficulties we can confront internationally when it comes to not having enough collaboration and coordination. Next slide, please. Now, when it comes to Indian measures, as I said in the beginning, I will be skipping the international aspects of it with regard to how globally aviation industry has suffered is something that we have is already referred to. So I come straight to the Indian situation. There are some interesting points with regard to public health, and these are concerns actually. When we look at the Indian scenario, what we find is that if you manually count, and there might be few plus or minus, DGCA, the regulator for civil aviation, it came out with 59 circulars in 2020, and till now 14 circulars has come in 2021. So therefore, finding out what is applicable, what is revised, is not an easy task when it comes to this situation. And I think this kind of a difficulty is faced in other countries as well. Now, one very interesting aspect is with regard to one interesting judgment that I have not mentioned in the slide. Nevertheless, Deveng Yogesh Kanani versus DGCA. Now, this judgment is very peculiar. In 2020, DGCA came out with an instruction that airlines are permitted to sell middle seats. However, they should be given a wraparound gown, and this should be in addition to the mask and face shield, and the airlines already have to provide everyone on board. So therefore, let's understand that we have seen detailed guidelines, and those of you who must have traveled during this COVID-19 times, they must have experienced this, that you have to follow the protocols when it comes to entering into the airport, then spending time in the airport, at the airport, and then embarking in the aircraft, how you conduct yourself, and then similarly when you come out, again move at the airport, you are spending time and then exit from the airport. So as our understanding of COVID-19 has evolved, similarly, as I pointed out in the beginning, our regulations have also evolved. So you have to have mask, and you have to, in the occupant in the middle seat has to have a wraparound. It has been a contentious issue whether the middle seat should be kept vacant or it can be filled. Eventually, over a period of time, it was realized that it is not possible, economically feasible, to keep it vacant. So therefore, this mechanism was found out. However, this mechanism was challenged in Bombay High Court by one of the pilots of Air India itself. However, the Bombay High Court permitted all flight operators to sell the middle seats, and they said that this should be done subject to strict compliance with DGCA. Unsatisfied and aggrieved, Devan Kanani filed an SLP against the decision, and two-judge bench of Justices Sanjay Kishan Kaul and Bhushan Gawai actually came out with a judgment in which they said that prima facie they were of the opinion that safety and health of passengers on board the aircraft is adequately taken care of, even if the middle seat is not kept vacant on account of passenger load and seat capacity. Now, here it is appropriate to mention in this context that when it comes to aircraft ventilation system, it is regarded as very safe when it comes to COVID-19 and even other kind of diseases. So this realization has been there. However, this cannot be stated equally with regard to airport ventilation system for obvious reasons, because airport provides facilities for a number of activities. So therefore, it's an entirely different kind of a situation there. Very contentious it was when you are asking for social distancing of 2 meters and plus distance when you are on the ground, while you are in aircraft, when you fill the middle seat. Very concerning it is psychologically also, that how safe it is. But things have worked out well, unless, as Professor Sandeepa pointed out in the beginning, that there are compensation claims coming when you can prove that you have caught the infection while you were on the aircraft. Another important aspect that has caught attention in a very peculiar way is this judgment, court on its own motion versus DGCA, where you have Delhi High Court Honorable Judge moving from Kolkata to Delhi, and he found that although the passengers were wearing masks, they were not doing it properly. It was below their chin, and there were people who were not listening to repeated requests by the crew with regard to wearing it properly. And then he actually converted it into a suo motu cognizance, and came out with a very interesting order where he said that we have to ensure that, and again, public health concern, we have to ensure that our requirements with regard to our mandates with regard to masking has to be properly implemented. And in pursuance of that, DGCA came out with a number of circulars, one after the other, in order to implement the directions given by the court in this suo motu case, some of which I have mentioned already. There is circular dated 13th March, wherein it was stated by DGCA that when it comes to non-adherence of wearing mask properly at all times, from entering airport before departure or exiting airport after arrival, including your time on board the aircraft, and if you do not maintain social distancing at the airport, then non-adherence will be taken seriously. And CISF and other police personnel, they will not allow you entry, and airport director and terminal manager also were required to ensure that this should be complied with. And non-adherence, now this is interesting, non-adherence during flight to these masking requirements will put you in the category of unruly passengers, which is part of para 3.1 of the CAR issued by DGCA. And unruly passenger, if you fall into that category, there are restrictions with regard to for how long you cannot fly. Similarly, on 15th March, another circular was issued where it was stated that airlines will provide digitalized directions, DGCA directions, with air ticket and boarding passes. You have to make passengers aware with regard to these requirements. You have to ensure strict compliance, and you have to ensure caution with consequence of non-compliance with frequent announcements, and you have to disseminate the instruction in this regard at prominent places. Moving further, another circular, 30th March 2021, enhanced surveillance. So DGCA conducted checks on the airport and found still unsatisfactory compliance at some airports. Masking nose and mouth was not there. Social distancing was not there. So they said that we need to enhance surveillance, and airports need to explore punitive actions, spot fines with local police authorities. Now, these are interesting developments. Number one, you need a High Court judge to travel and then convert it into a suo motu proceedings, and then issue directions, and then those directions, then DGCA takes up and apply, which should have been done without this kind of a route.
Professor Tyagi, sorry to interrupt you, sir. You have another 3 minutes to wrap up.
Yeah, I will. Thank you. And not only that, there were news reports where it was indicated that 3 airlines acted against 7 passengers dated March 15th and 16th. So therefore, airlines also swung into action because of this kind of a mechanism. It shows effectiveness of what happened, but we could have done better on this front. Then, can we move to the next slide, please? Now, what kind of challenges are there ahead for us? Well, numerous when it comes to public health. Number one, viruses, they naturally evolve, mutate. So therefore, epidemics recurrence will definitely be there. It is all about whether we are actually prepared in terms of our legal or regulatory framework. Second, public health infrastructure within the nation varies between states, and at the international level, they vary among states. So therefore, this differential has to be reconciled. And how do you reconcile? You cannot reconcile it through knee-jerk reaction, which we have seen in a number of countries. And so therefore, there has to be a coordinated approach, which was pointed out by Professor Attila in his presentation. And rightly so. We need to have international and regional organizations. They need to coordinate and have a harmonized approach, because this COVID-19 and our experience with regard to how we have suffered is an eye-opener for us. A differential approach internationally. So we have seen, look at United States itself, whether you should mask or you should not mask itself became a electoral issue there. And we have seen how things have been there. So there is a lot of requirement. Maybe move to the next slide, please. There is a requirement with regard to how all stakeholders are going to realize their individual responsibility. Enforcement, lawmaking is one part of it, but then, and we have seen as to how in India, through the example that I have given, how difficult it has been. But then, you know, somewhere individuals need to realize their responsibility. Even the financially well-to-do people and the people who are well qualified, you will find that they will not be adhering to the spirit of masking or social distancing itself. Now that poses a huge public health challenge in the context of aviation, to which I have already highlighted partly. Vaccination is considered as, and is presented also as the most potent safeguard through which aviation will come back to its wheels. But then we have seen what kind of reluctance is there in countries and amongst people with regard to it. So a lot of work has to be done. While this passport, where you have this requirement that unless you are vaccinated, even India has raised its concern with regard to that. So these are some of the aspects which needs to be worked upon. I have this feeling that when it comes to a passport, even the Covishield was not included. And then we were told that the requirements were not met of submitting the records. I'm sure that will be taken care of. But then the larger issue is that how do you get over this vaccination challenge, which has a direct bearing on aviation coming back on track. And as pointed out earlier, it is nothing new for aviation to face these crises. Every time it has come good and come with flying colors. However, this time the crisis is far more comprehensive. And so therefore, I think this is the right time when we need to seriously think about restructuring our international framework. One interesting point is that whether we should have 20th next year. At the national level also, we need to do better in terms of public health infrastructure. Otherwise, piecemeal initiatives will not help. Well, on that point, I'll conclude my presentation. If I have overstretched my time by a few minutes, I'm sorry for that. And thank you for helping me with the presentation of the slide. Thank you very much.
Let me thank you very much for the kind introduction. I'm Patrick Honnebier, located right now in Amsterdam. And on my screen, you can say you, well, you is me, all right? So it doesn't mention Patrick Honneby for whatever reason, but that is me. Thank you very much, but can we start with having my presentation? Because I requested that someone at your end would turn the slides. I am not capable to do that. I can't do it. It's just not my kind of cup of tea. So whoever is in charge, but you are, let me already start and not lose time. Again, very kind of you to introduce me and certainly to invite me to do this presentation. I would like to comment one thing or add one thing to the introduction, who I am. And that is that indeed, I am a professor, international aviation financing and leasing laws. But what I would like you can already, anyway, let's wait. International aviation financing and leasing laws. What I would like to add is that the University of Mississippi, the LLM program, Master of Laws program in Air and Space Law worldwide, is the only one that offers this special course, International Aviation Financing and Leasing Laws. And that makes us kind of different from other universities, which are also offering, and there are not that many, as my dear colleague Sipa knows, Professor Sipa, Attila, you know it. There are very few who also offer an LLM in Air and Space Law, but Mississippi is the only one. All right, now here we go. My presentation today is called The Impact, can you go back one slide, please? The impact of COVID-19 on the international aviation finance and lease practice at large, and in India in particular. I'm focusing, therefore, as much as I can on India. Next slide, please. Right, I already mentioned who I am, and you introduced me so kindly. So, well, other speakers have been talking about what is happening worldwide, disastrous cases, matters, and particularly in India. Now, if indeed there is some kind of a lease agreement, I'm sure most of you know that most carriers and also particular operators in India lease the aircraft. They don't own them, no, they lease them. Now, if indeed something goes very bad, what can they do? I mean, I'm talking now on behalf, let's say, of the side of the lessors, the financiers, not of the side of the airlines. And the reason is basically because my practice is mostly focusing on lessors and banks. All right, what can they do? What can the stakeholders do right now when it goes very bad with lessors, operators, private or commercial ones in India? Now, in essence, they have two possibilities. But what happened? COVID, you know, in 2020, 650 commercial aircraft alone, only commercial aircraft were grounded over 22 Indian airports. What did IATA say about this? Because, you know, they represent airlines. It said India's scheduled carriers are currently in a grave and immediate danger of insolvency. And that is still true until today. We all know this. And we'll see it later on, what exactly is happening. Okay, as to date, the international aviation lease practice must therefore properly react. As I say, what can they do? Now, which legal remedies? In essence, they have two options. Two, and that's it. They can litigate in English courts. And why? Because I already tell you, because most agreements, lease agreements with Indian operators have the clause jurisdiction England, not the UK, that's impossible, not Scotland, not Wales, no, England, England is the Walhalla, apparently they say, right? So most lease agreements, finance agreements with Indian operators have the clause, we must go to England. Now, that is one option if it really goes bad. Secondly, what can they do? They can repossess the aircraft outside India. Why not inside India? Well, that takes a very, very long time. It takes a very, very long time. Practice showed this. So, of course, you try as aircraft lessor to do what you can. And I can tell you that aircraft lessors are not really always the bad wolves, as they are always, or not always, very often portrayed. Lessors, oh, they are the bad guys, they are the bad guys. I can assure you, they have a long breath already normally, let alone in days of COVID. Very, very patient they are, and they try what they can do, I can assure you that. But still, in worst case scenario, what do? I recommend not repossessing India, hopeless. Repossess as soon as you can outside India in a state where they abide laws and international treaties. Next slide, please. Alternative one, litigation in English courts because they decide to do that. That scenario. Case one, a recent one, Wilmington SpiceJet. Now, almost everybody knows about SpiceJet, and certainly in India, the people from India, they know that SpiceJet is not financially extremely healthy. Can we go to the next slide, please? We all know this. They are financially great trouble, and basically they survive until today because the Indian government has decided to put a lot of money in it, so they still fly. All right. Nevertheless, there was already a court case. The Wilmington Trust in Dublin, SpiceJet, India, ruled decision recently, April 30, 2021. So it's only a couple of months ago. What happened? 3 aircraft leased by the Irish lessor to SpiceJet, choosing, as always, English law, right? Okay, and English jurisdiction. Why does it go argument? That is alleged, yeah? Allegedly, that is what SpiceJet is arguing. Yeah, because of COVID, and we are talking today about COVID, and also about the disaster and the terrible accidents of Boeing 737 MAX aircraft, right? So that was the reason why they argue why they don't have money today to pay the lessor, this one and others. Now, typically, most of us will know this, that do practice already, that when you go to court in England, it can be very lengthy. And also in this case, as far as I know, let's say it took 1.5 years, okay? So, and it is very expensive. My colleagues who do international aviation finance and lease law in London are not known for their cheapness in the sense of being charging low fees. Absolutely not. So costly. For 1.5 years, they were in court in London. What did the court say? The justice, the judge, in all her wisdom, she said, okay, I agree with the lessor that they have the right to get their money, to put it very simply. There is what we call a clause in every of those agreements, hell or high water clause. So lessee, under any kind of condition, has to perform and pay lessors. I agree with that. However, and now it comes, she also said in all her wisdom, yes, but still I order my ruling to stay because I think it is wise that the parties will now start mediation. Now, yeah, can you believe it? After 1.5 years, court cases, court appearances, costly, lengthy, etc., that the court will say, yeah, you know what, go back to the negotiation table and go negotiate what, for how long? Another half year, year, another half? What is this? So the international, not only in England, but the international aircraft finance lease community is not particularly happy with this outcome, you can imagine. Conclusion, English law jurisdiction, I don't think so. This case has proved that waiting another year and a half, of course, SpiceJet is happy. They don't have to pay the old fees, the debt, and not right now. So they are happy. Next, please. Alternative 1, case 2, Blue Sky, Mahan Air. Can we go on, please? Next slide. Mahan Air, what happened? This is not directly an Indian case. However, as I just said, in all these agreements, choosing English law, all right? English law, English jurisdiction. So it is relevant also in all those Indian cases that may come up or already are pending, etc. All right, what happened in this case, to put it very simply, because it was also a long case, very, very costly, very, very costly. It concerned, again, parties, well, many parties, but lessors, let's assume, in England, and lessee was ultimately lessee, very difficult, but let's assume that it was a lessee in Iran. You could see the aircraft, it considered Boeing 747, 2 of them, all right? In essence, they were stolen. One was stolen up in the pocket by Mahan Air, with all respect for Iranian listeners to this conference. In any event, what did the court say in that case? The court said, okay, I agree, it was an English mortgage. We're talking now about English mortgages. Very popular, again, very popular English mortgages, not Indian ones, English ones. English mortgage in an English aircraft, etc. Everything was English. I'm an English court. However, the court ruled, and very, very true, it had totally right. It was totally right. It said that choice of English law has no effect at all in regard to the question at issue whether the English mortgage in the English aircraft was valid or not, and you can execute it and force it, yes or no. So English mortgage, it was $43 million down the drain. Now, can you imagine that the worldwide community of aircraft financing was happy with this English case? No, they were not. Again, choosing English law, is that always that grand? No, it is not always that grand. Can we go to the next slide, please? Alternative 2. Here we go. An Indian case. Not now a commercial aircraft. No, this time a corporate aircraft. A corporate aircraft. It is, we are talking now, or I'm talking now, about repossession outside India. Alternative 2, do not wait for years. No, do maybe possibly take another route. What can you do? This certain aircraft was a Bombardier private aircraft, Indian registration. It is, can we go to the next slide, please? Already can you believe it, already grounded at an airport called Biggin Airport near London. A small one is cheaper, you can imagine, for 11 years now. For 11 years, it is grounded. Is that good? No, it is not good. What happened here? In this case, there was an aircraft lessor which leased that particular aircraft, which was operated, used, flying by a certain guy called Lalit Modi. Those of you, maybe older ones certainly, that like cricket, know that Mr. Lalit Modi was the cricket guy of the Premier League in India. He was operating this aircraft. As a passenger, as private aircraft. All right, so this was leased to an operator in India, but also the lessor in Ireland, there was an Irish lessor, had to get money. So a mortgage, again, English mortgage, an English mortgage was given to the mortgagee bank in New York, right? You understand? So a lease between Irish lessor, Indian lessee operator, and the Irish lessor needed money. So as mortgagor, gave an English mortgage to the US mortgagee. The aircraft, as I already mentioned, as from July 23rd, 2010, 11 years now, is located at Biggin Hill in London, in London area. Why? Because the let's say DCA India, that is a Directorate General of Civil Aviation India, DCA India, until today refuses to deregister that aircraft from the Indian Nationality Registry until today. Why? Because the Indian Tax Ministry, Department of Tax of the Indian relevant ministry, argues that there was a tax scam. Mr. Modi and his gang were involved in a tax scam. So we do not deregister that aircraft. You can ask yourself immediately, what has that New York mortgagee got to do with the tax scam of an operator from India in India? What has that? What does the lessor have to do with that? What does the mortgagee have to do with that? Until today, Indian government doesn't care. They say, we don't deregister. Okay. Consequently, 11 plus years grounded. Can we go to the next slide, please? Can we go to the next slide? All right. In the beginning, what happened? 2 court cases in India in 2013. First court case, corporate aircraft funding, the bank, the mortgagee against the State Union of India. What did the court say? Very wise. It said there is a Cape Town Convention that applies in this case. An international treaty applies in this case. So DCA India, you must deregister that aircraft already in 2013. Second case of a court of appeal. The tax people went in appealed, and what did that judge say? That judge entirely ignored the application of a treaty, the Cape Town Convention, which India already adopted in 2008. Totally, in his ruling, that judge ignored it. While, of course, the stakeholders argued that it applied and everything. It just couldn't care less, the court. Couldn't. All right. What happened subsequently? The lessor of the aircraft in Ireland went bankrupt in 2019. So that's the third case in this matter. Irish case, 2019. Corporate aircraft requested the financier bank in New York, mortgagee, that lessor would be declared bankrupt, which happened. But until today, nothing happens. So the Irish insolvency administrator, doesn't do anything. All right, next please. Thank you. What do international treaties say which apply in India, all right? Like Chicago Convention. What does they say? First, Chicago Convention says you can validly register an aircraft in only one country. Validly. Underline it 3 times. Validly, validly, validly. So, but you can also move from one state to another and deregister and register in another country, says Article 19. That's what it says. But what is important here is that the Chicago Convention does not mention anything about deregistration, how to do it, how it works, or registration, how it works. That is left to the states. So some states have a good registration, deregistration system, or a bad one. Okay, so they decide themselves, unless, and now it comes, unless a new self-executing ICAO treaty dictates a uniform deregistration procedure, because then the national one doesn't apply, but the international treaty applies. You can imagine, for all its member states. Next slide, please. This is the Cape Town Convention. You see, it has been adopted by now 80 states and the European Union, including India, since 2008 in India. And it is, I emphasize, I stress, self-executing. It doesn't require the member states. It has always been adopted, for example, by Argentina, Professor Fulci, for example. All right, that's one of the contracting states. However, it is a self-executing convention. It doesn't care whether a country implements it at all, or rightful or wrongful. It should be rightful, and it should be done, of course. However, India is creating a fuss what that is concerned. Can we go to the next slide, please? What does the Cape Town Convention in brief say about deregistration? It has a uniform for all those 80 states, including India, deregistration procedure. It says that in international interest, that is comparatively, you can compare it to an international mortgage or charge, whatever you want to call it, pledge, give it any name. An international interest exists under the Cape Town Convention, which you can register in the international registry in Ireland. You can do that. So also in this case, you could do it, and that has been created. So this treaty applies in all its parts in India, that's for sure. But Cape Town also provides for a so-called irrevocable deregistration export request authorization. And that means when, in this case, the lessor gives a certain certificate on behalf of the creditor, which in this case was the bank Corporate Aircraft Funding mortgagee in New York. So it presents that, it gives it to the Indian DCA. That DCA has to deregister that aircraft upon the request of that certain, what we call yeah, the authorized party, and in this case, it is the bank in New York, corporate aircraft funding. That has happened beyond any doubt, Consequently, because until today, DCA India refuses to do so, the registration, in brackets now, registration India, is invalid. It no longer exists validly. It infringes, it is contradictory to the treaty that India adopted, so there is no longer a valid registration of this aircraft in India since 2012. Yeah, I'm almost there. I'm almost there.
Sure, sir. Would be grateful if you could wrap it in a couple of minutes.
Yes, I'm almost there. Consequently, as it is no longer validly registered in India, no, it isn't, because, you know, in fact, it is a tort. In my country, what India DCA is doing would be a tort. So if this would happen in the Netherlands, when I'm located in Europe, I would advise my client, fight against the government and ask for damages immediately. Start with it. It is a tort, what they are doing. But yeah, India, I'm not sure. In any event, next slide, please. The Chicago Convention is not infringed. All right, registration, deregistration articles are not infringed, because if you now register that aircraft in another country, it is valid, and it is only valid there, and it has been already for I don't know how many years no longer valid in India. Okay, now what does it comes the news is that the Netherlands, where I'm located in Amsterdam, we created a new law which entered into force and that implements the Cape Town Convention in a totally novel way, which has not been done yet by any other country in the world that has adopted the Cape Town Convention. Well, all right, what does my new law say? It says, okay, now, when, under what conditions can you register an aircraft, corporate or commercial, in the Netherlands? Okay, it says aircraft imported, that means from another country now registered here, can be done, but proof has to be submitted that the aircraft is not or no longer registered abroad. Okay, that is normal. There's nothing new. But now it comes to new aspect. The aircraft must be registered from a foreign registry under the Cape Town Convention IDERA rule. If that applies, like in this case, India, then you are welcome to register this particular aircraft or others in the Netherlands here, and you obtain the flag of the Netherlands, PH, which is well established, recognized all over the world. It is not some kind of shady country, and I'm not referring to India now, but everybody knows there are certain jurisdictions that do not have a good reputation as far as registration of aircraft are concerned. So can we but the Cape Town Convention must apply. Can we go to the last slide, please? Practical consequences is you register this aircraft in the Netherlands, you get the flag of the Netherlands. You can do so temporarily, right? As long as you want, or longer, or forever, it's up to you. But then subsequently, you can lease it out again to another country, right? Or you can sell it to an operator in another country, because if you don't get otherwise registration, your aircraft is worthless, like the one right now at Biggin Hill Aircraft near London. It's practically becoming worthless. Now, and that is important. That would facilitate global deregistration problems like the COVID ones that arise now because of COVID. Can we go to the next slide? And I want to add one more thing. Be careful, like always, that you get local representation which is adequate, that knows about the law applicable, like the one at hand. My law firm has advised our government, took more than 4 years, 4 to 5 years, finalizing this new law in consultation with ICAO, for example, and with other countries. It was not that our country, my country, just all of a sudden had this idea, you know what, we are going to do something and we don't give at all what the law says or anything like that. So be very careful, because unfortunately it happened already that interested stakeholders went to the wrong lawyers, and I don't think that's advisable, because they were very much concerned of the outcome of whoever they retained. Well, thank you very much for listening to me. That is what I would like to say. And one more thing, this is not India bashing. Please believe me, I do a lot of work with India. It's not like that at all. But we are talking today about India. The focus is India. I could have talked about other countries too, but the cases were having relationships, direct or indirect, with India. Thanks again.
Good morning to everybody. Good morning for me, at least. We are here in Buenos Aires in plain winter, and it's very early in the morning. But I'm very pleased in replying the kind invitation of Professor Sandeep Abad to talk to you about a topic which is very interesting, because it's very significant nowadays. This has always been so, because civil aviation has a peculiar dynamic that is transmitted to aeronautical law, which is the legal branch regulating such matters. Without any doubt, aeronautical law has an important subject added with the pandemic, because it has affected travel and tourist business, as you all very well know. Also, in the last few decades, the so-called consumer law has added certain elements to the matter, since certain legislation, opinion of legal scholars, and case law understand that the legal relationship between the air carrier and its passenger is a matter of consumer issues. Although I disagree with the latter, I am aware of the fact that such consumer law, which was created by detaching all civil and commercial law principles, even giving them a constitutional standing, as it occurs in Argentina, for instance, could be reasonable where it refers to daily relations in a person's life, but poses interpretation difficulties where we deal with an old institution, such as an air transportation contract, which has major worldwide significance both domestically and internationally. Let's take into account that we are just 9 years ahead of 1 century life of the Warsaw Convention, which has given the first general legal framework of the air transportation contract. And in many countries, the national laws regarding aviation, civil aviation, are inspired in the Warsaw Convention. The matter under review, for academic methodology reasons, causes us to recall certain general principles. I think it is very important to take it into account. And some years ago, I defined what is the air transportation contract. For me, a passenger air transportation contract is an agreement whereby a carrier agrees to carry one or more persons with their luggage by air in an aircraft from one airfield to another within a certain time and safety conditions for a certain price in money. We can, from this notion, separate their constituents. The transportation is done by air. Is carried outside the land surface. The transportation is done in an aircraft from one airfield to another. That is, in an apparatus or device that can travel by itself in aerospace and can carry on persons or things, and does so from a point of departure to a point of destination. The transportation must be done within a certain time, which implies the importance of complying with a certain schedule. And finally, the transportation must be done under safety conditions, which means the passenger must arrive at his or her destination safe and sound. From this notion, we may consider the possibility that the contract may be one contract, a successive contract, or a combined contract, depending on which is the travel which the passenger has by to the airline. The vast majority of legal scholars understand that the primary characteristics of the contract are the following. First, the contract is consensual. It means that between the passenger intending to be carried and the carrier intending to carry the passenger under the relevant contract. Two, the contract is bilateral, which means that there are two parties to the legal relationship, the passenger and the carrier. Three, the contract is for value. It means that the carrier is out to make a profit by carrying the passenger. Although there are certain passenger transportation contracts that are not for profit. For instance, when an airline agrees to carry an employee of another similar business without charge, the usual situation is where the passenger pays the price of the air ticket. 4, it is not formality-based, since no specific writing is required, and in turn, the contract may be shown by any means of evidence. At this point, has been debated if a passenger air transportation contract is an adhesion contract or not. In my opinion, it is not, because although in the first few decades of the formidable development of air transportation worldwide, since the Second World War, ticket forms were issued pursuant to criteria determined by the IATA, International Air Transport Association, as there was a mass dissemination of flights worldwide and computers began to appear. The initial rigidity gave way to numerous possible choices available to a passenger at the time of deciding upon a certain trip. Not only as to the route and the carrier, but also as to certain clauses passenger may or may not accept them, among the various choices that can be offered by the prospective carrier, the price and so forth. For a long time, I have believed that the appearance of electronic devices brought about the second great revolution in air transportation, after propeller engines have gave place to reaction engines, because, among other things, computers substantially modified programming, development, and performance of trips by airplane and the legal relationship created between the carrier and the passenger. Nowadays, a passenger directly from his or her own computer or else with the assistance from a travel agent has a broad range of choices before deciding to purchase a travel ticket for a certain air travel. As to the legal nature of the contract, it is derived from the civil law contract for services, since the carrier agrees to carry the passenger under the agreed conditions by air in an aircraft from one airport to another, safe and sound. This implies that the obligation consists in doing something if we follow the conventional classification of duties in duties to give, to do, and not to do in the traditional civil law. We have, as derivation of this concept, we can see very lightly the rights and duties of the parties. And so, the carrier has the following rights vis-a-vis the passenger. One, collecting the agreed price. B, conditional acceptance of the passenger for the flight. And we have had several circumstances. And in Argentina, for instance, the case law provides a long range of sentences in judiciary tribunals. And, well, reasonable amendment of contract condition and demanding the compensation of damages caused by the passenger could be another right of the carrier. So which are the carrier's obligations? One, passengers transportation, of course. Reimbursing all or any portion of the price paid by the passenger. And then you will have in the paper the some details of several sentences of the tribunals in Argentina and in some countries of Latin America. But the passenger has several rights in an air transportation contracts, which are usually analyzed from the standpoint that he or she is a consumer, from which a set of legal premises and criteria derives that seek to make it fall within the respective legal framework of the vast field of consumers' defense rights. Notwithstanding the legitimacy of this defense in the general business realm of any organized community, I have clear that in the case of passengers' air transportation contracts, given their legal nature and because the domestic and international rules of the different countries are effective and constitute an appropriate framework for the nature of this contract relationship, it is not necessary to resort to rules and procedures that lack the specialty inherent to this matter. The first aspect that should be analyzed in this situation is that in this type of contract, the passenger is not a consumer in the strict sense of the word, but a contracting party in the relevant relationship. I have held that this contract cannot be construed as a contract of adhesion, despite the fact that the passenger, in practice, does not argue most of the contract terms and conditions. But it is also true that when he or she decides to perfect the contractual relationship, they they are well being fully aware of the price and other terms thereof. In addition, and this only allows to reject the criterion that it is an aviation contract, nowadays, computerized booking systems through which carriers insert the selling terms of their products allow the passenger to analyze different alternatives of flights, tariffs, hours, and other conditions offered by a carrier before selecting an option and entering into the contract. Therefore, the passenger does not choose to pay the price of the trip and accept the other terms of the contract as a single possibility, but rather can analyze several alternatives among those offered by the system. Moreover, this selection may be made among several carriers. Finally, the passenger makes a decision that confers him or her certain rights. A second important aspect indeed is that this contract has been one of the most thoroughly regulated, not only in the history of aeronautical law, but of all international trade over 1 century. A third element supporting my opinion is the criterion with which we should approach the study of aeronautical law. Actually, it governs civil aviation, one of which parts is air transportation, which is more than the mere deployment of aircraft, as it represents the complex notion of a deep knowledge of a sector with permanent and multiple interrelationships, which act together and which ultimately will allow its full development and make it an essential progress factor in any country. Facilitating the legal breakdown of any of the sectors making up civil aviation is an actual damage to it as a whole and to a comprehensive notion of its structure and functioning. We can also analyze different other aspects with the rights and duties of passengers and carriers. You all well know the problems created by overbooking, which I studied several years ago. And for instance, the Argentine law courts have deeply studied this, and in one sentence from more than 10 years ago, they have installed a concept which is very interesting, because as you know, overbooking always derives in a retard, in a, how we could say, in a loss of time. And our tribunal said that loss of time is also loss of life. This is a very interesting concept because it means that the carrier cannot dispose of the passenger's time, except in such circumstances, by nature or by time, which can make the impossibility of making the trip by the carrier. So I will finish this trying to attend the time prescribed by the organizers. The performance stage of the passenger air transportation contract is established at international level by the current treaties and at domestic level by the respective laws, most of which follow the criteria of the treaties as to temporal application. For example, since the boarding begins until unboarding ends. As final paragraph, it is clear, taking into account the rights and obligations of the passenger and the carrier, as well as the absolutely unique event that an airplane trip represents in respect of the set of human and business relationships. It is imperative to encourage exclusive attention to the rules of aeronautical law for this air transportation contract, disregarding any other. Along these lines, Argentine case law has protected the passenger as one of the parties of the passenger air transportation contract under consistent principles and under domestic and international rules that provide a framework to the sole contractual institute. Thank you very much, and I would be very honored. I was very honored to be able to make this presentation. Thank you very much, Professor Sandeep Abad, and to you all.